So now we are continuing with article number 22, which is again under right to freedom, the last article in the right to freedom. And this is something which is very much in news for some or the other reasons, because certain provisions of this article deals with the issue of preventive detention, which, as I've said, that as a separate topic I'll do in the series of issues related to fundamental rights in the end, once I finish all the articles. So in fact, on 6th of September 2022, like very recently, there was an article which is giving the present day, or the, let's say, the not the present day but the contemporary data about released by NCRB, the Crime Records Bureau, which gives the idea for 2021 preventive detention cases. So therefore this topic contemporary also becomes very important, and otherwise also is very significant. So firstly, we'll see in the Constitution, what does Article 22 say? Now you can see that there are many clauses, 1, 2, 3, 4, 5, 6 and 7. You can see there are 7 clauses in this article, and therefore we need to give adequate attention to all these clauses of article number 22 with adequate attention. The first thing that it says is protection against arrest and detention in certain cases. Now see the keywords here. Firstly, it is telling you certain cases. So they are specifying what all cases are covered here. Then the protection here is against arrest and detention. And you can see it is about person, all of that is about person. So you should understand that this article, all the clauses are applicable for the person, which means citizens and non-citizens both. But before we proceed with the clauses, when you get these two terms, so our first responsibility is to understand what is the difference between the term arrest and detention, because people usually get very confused with these two terms. So therefore we'll try to look into this idea of how do we differentiate between arrest and detention first, before we go and continue seeing the article's content. When we talk about arrest and detention, arrest is about, let's say there is a person who has committed a crime, or who is actually charged with a crime, and the police takes away the person, or let's say in other words you say that the police arrested the person, so takes away the person. So for arrest to happen, what is the basic condition is that you already should have done the crime and you are convicted for that. Strong evidence is needed, definitely. Very severe offense should be there. It will include being fined or imprisonment, or even both if the person has been convicted. So here the idea is that, and if the person has to let this go, then the person needs to get the bail granted from the court. So there are many crucial aspects related to the word arrest here. But when you see the word detention, here the basic idea is that the police keeps someone in official custody to ask questions, or let's say you say investigate, with respect to any particular matter or crime. But it is not important here that the person has already committed the crime or not. The person might not have committed the crime also, and that is also we'll discuss in some time. So here basically the idea is on the basis of getting this idea, suspension, that okay, we need to investigate this person, but as such there has been no trial or not convicted by the court, then in that case detention happens. ठीक है, उनको वो detain करके अपने साथ रख लेते हैं questioning करने के लिए. Now when we talk about detention, there again are two basic ideas of detention, or two basic categories if you say so. One is your punitive, another is your preventive detention. When we talk about punitive detention, it means that you need to punish a person for the offense which the person has already committed, right? So trial has happened, conviction in a court has happened. So convict मतलब उसको दोषी करार देना. So all of these things have happened, and then a person is punished for what the person has done. That is punitive detention. Preventive detention, on the other hand, is about detaining a person without trial. So no court process or no trial has happened. The person has not been convicted. उनको कोई दोषी नहीं बोला गया है. So this is actually a precautionary measure, as you can see here. Precaution की तरह हम संभल रहे हैं पहले से. Why? Because let's say we have an apprehension or a suspicion that this person might do something wrong or commit a crime in the near future. So to prevent that from happening, let us detain the person in advance before doing any act. That is your preventive detention. Now there are many other details of preventive detention which I have told that I will be doing in the issue series. So for the time being, just understand this basic meaning of preventive detention, because to understand Article 22 and the associated content, you need to see this difference and understand this difference. For the time being, only this much understanding of preventive detention would be okay. But don't worry, everything which is given in the book and some additional information I will be sharing in another video. Now let's go to Article 22 and see the contents one by one. Clause number 1. It says, no person. Now please notice that this article actually can be divided into two parts. Two parts in the sense, these clauses, clause number 1, 2 and 3. So the first 3 clauses till here is dealing with any kind of ordinary law and normal cases of arrest. Okay? Not preventive detention. These first three clauses are dealing with normal cases of arrest and detention. From 4 till 7, 5, 6, 7, these are dealing with preventive detention. I hope you understand. So two parts we have to cover. Firstly, the part that we will be seeing will be dealing with the cases of ordinary law, and it will talk about the rights of a person who is arrested or detained. Now you know the meaning of arrested or detained, okay? So when a person is arrested or detained normally, not a preventive detention, okay? So what would be the right given to that person? This is what these articles talk about. Firstly, it says that if a person is arrested and or detained in custody, the person needs to be informed. So no person who is arrested without being informed as soon as maybe of the grounds for such arrest. So if a person is, in short, if I have to tell you, if a person is arrested or detained, the person needs to have the information about the grounds of arrest, that on what basis or for what reasons the person has been arrested. Also, the person shall not be denied the right to consult. So the person needs to be given that right to consult or the right to be defended by a legal practitioner of his choice. So basically, a legal help in this case is a must, and also the grounds of arrest needs to be informed to the person. So let's see. Right to be informed of grounds of arrest, right to consult and be defended by a legal practitioner. Okay, these are two rights which clause 1 gives you. Let's see clause 2. What does it say? Now, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of arrest. So when the person is arrested or detained, the person needs to be presented to the nearest magistrate within 24 hours of arrest, excluding the journey time, because from the place of arrest to the time that you take to travel to the court of magistrate, some time would be needed for that. Therefore, they have also clearly written nearest magistrate so that you reach sooner. So that time is excluded, but otherwise 24 hours, within 24 hours, the person needs to be present in front of the magistrate. And also, no such person shall be detained in custody beyond the said period without the authority of a magistrate. Now, what is the said period here? 24 hours. So the person can be held in custody only till 24 hours. If the magistrate then further says that the grounds of arrest or detention are genuine and the time period should be extended, then only it will be extended. So basically, the authority of the magistrate is needed to extend the time period of detention. Okay, so this is again continuing in the right. right to be produced before a magistrate within 24 hours, ordinary excluding the journey time, and right to be released after 24 hours unless the magistrate authorizes further detention. I hope clause 1 and clause 2 are clear to you. Now what you have to notice, that we have said that these are available to the persons, therefore it is not available to the enemy alien. The persons will include aliens, definitely citizens and non-citizens, but not the enemy alien or a person who is arrested or detained under preventive detention. And where is this criteria given? This criteria is given in clause 3. So it very clearly mentions that nothing in clause 1 and 2, above two clauses, shall apply to any person who for the time being is an enemy alien and also who is arrested or detained under any law which provides for preventive detention. So the first 3 gives idea about the normal arrest or detention ordinary law के cases में. ठीक है, so these are all the rights. Also, the Supreme Court has clarified that the arrest or the detention which happens in this case apply, and the rights which are given for that apply only to the criminal act or of the acts which are of quasi-criminal. Quasi means kind of semi-criminal, having certain criminal elements in that. It is not for the arrest under order of a court failure to, let's say, for example, if the court has ordered arrest, if somebody has failed to pay income tax, etc. In that case, these rights do not allow. These are only for the criminal issues or quasi-criminal issues. I hope these articles are, or let's say these clauses are clear to you. Now that we have seen for the normal cases, we will move to the preventive detention case, which deals with a clause of 4, 5, 6 and 7. Number 4 says, no law which provides for preventive detention shall authorize the detention of a person for a longer period than 3 months. So for ordinary arrest or detention, what is the maximum period? 24 hours, unless the magistrate gives the authority to extend it. But for preventive detention, what is the maximum period they are talking about? 3 months. But there are certain criteria. So it gives you unless also. So it shouldn't be done for more than 3 months unless 1 and 2 criteria. Firstly, an advisory board consisting of persons. Now I'll, for the time being, not read this part, that who will be the component or consisting of the board, so that you do not get confused in reading this. So let's skip the underlined part for the time being and read the remaining parts. So unless an advisory board has reported before the expiration of period that there is in its opinion sufficient cause for such detention. In short, it means if the advisory board says before that 3 months period expire, so before that 3 months period expire, if the advisory board says that there are certain important grounds or causes for such detention to continue or extension to continue, then only extension beyond 3 months can happen. Like in this case, the magistrate's authority was needed for the extension. Here the opinion of the advisory board would be needed, their report would be needed for the extension beyond 3 months. Now who will constitute this advisory board? Any person who is a high court judge or who has been a high court judge or who is qualified to be appointed as a high court judge, which means having the qualifications of a high court, qualifications of appointment of a high court judge. Anybody for that matter. So just remember, it is related to the high court judges. That would be okay. So if they give the report that yes, there are sufficient grounds which exist for continuation of this extension of the detention, then the person can continue to be in detention, which means maximum 3 months is given by the constitution. But in reality, this can be extended if the advisory board says so. I hope that is clear. Then it also says, provided that nothing in this subclause shall authorize the detention of a person beyond the maximum period prescribed by law made by parliament under subclause B of 7. ये इसकी बात हो रही है कि यहाँ पर भी क्लॉज दिया हुआ है कि मैक्सिमम पीरियड को पार्लियामेंट कह सकता है. So there are 2 cases now. One, advisory board will give the report, or if parliament has made a law which provides for the preventive detention, and in that law the specific time period has been mentioned. ठीक है, let's say 1 year or 9 months or 8 months, whatever period has been mentioned, that would also be allowed. So advisory board का भी allowed होगा, और parliament जो law बनाएगी for preventive detention, that would also be allowed, whatever time period they will mention. Second exception, they say that such person is detained in accordance with the provisions of law made by parliament under subclauses A and B. The same thing. Okay. Now next is number 5th. When any person is detained in pursuance of an order made under any law. Now when a law would be made, then the executive will release an order, law will be made by the parliament, and then the executive will release an order that now we need to detain the person, because it is executive which executes the law. I hope these fundamentals are clear to you. So if an order comes that the person is getting detained under this preventive detention, so the authority which will make the order, which means the executive authority which will make the order, will have to communicate the grounds on which the order has been made to the person. See, understand this very fundamental concept here. They are telling that these two clauses are not applicable for the preventive detention cases, and in this case it was given that the grounds of the arrest has to be mentioned, which means if arrest and detention is happening for the ordinary law, then the grounds of arrest has to be told to the person and legal aid has to be provided. But if preventive detention is happening, for which the maximum period is 3 months by the constitution, no ground needs to be given and there is no provision of legal aid here for the 3 months. But if you are extending it beyond 3 months, either by advisory board report or by the law of the parliament, then you have to communicate the grounds on which the order of extension, this order means order of extension, has been made, right? And you will also have to give the person, which means give the person this affordability, earliest opportunity to make a representation against the order. Okay, which means inform him or her as soon as possible, so that the person gets earliest opportunity to make a representation against the order. If a person is not satisfied with this extended preventive detention order, the person can claim things against it. Then what the court will decide is a different issue, but at least the person gets an opportunity. It's not that the person has no say in it. Okay, but for the 3 months there is no say. Okay, remember this. Also, nothing in this clause shall require the authority making such order to disclose the facts which such authority considers to be against the public interest to disclose. Now, when we are telling that the authority will have to communicate the grounds of extension, in that case also the authority is not mandated to disclose any important, let's say, any secret fact or something which they feel that it can go against the public interest. उसमें उनको छूट है कि they cannot disclose it. If they wish to, they cannot disclose it and it will be okay. ठीक है. Next is the last clause. Parliament may by law prescribe. अब parliament के पास भी power है to make a law, and then in that law they can prescribe that under which circumstances or under which class or classes of cases, I mean under what cases, under what circumstances, the person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of advisory board. I hope you get the point. Advisory board के पास तो है ही permission, ठीक है, but let's say this is for something, अगर कोई इसके लिए law exist नहीं कर रहा है, but अगर parliament ने कोई ऐसा specific law बनाया है and if in that law only they mention a specific period which is more than 3 months, then they are allowed to do so, and for that they do not need to have the opinion of the advisory board. For example, there is a act, National Security Act, ठीक है, National Security Act, which is also act related to preventive detention. In this the arrest can go till 12 months also. तो by law it is allowed. Circumstances भी बता सकते हैं, cases बता सकते हैं जहाँ पे वो longer than 3 months allow करेंगे. Also they can talk about the maximum period for which a person has to be detained. under preventive detention. By law, Parliament can do that. Also, the Parliament can talk about the procedure to be followed by the advisory board in an inquiry. तो यहाँ पे जो इंक्वायरी की बात की जा रही थी उसमें क्या प्रोसीजर फॉलो होगा वो भी पार्लियामेंट बता सकती है. तो द पार्लियामेंट कैन गाइड द advisory board. Let's just quickly summarize this here again. So it is protection to persons arrested or detained under a preventive detention law, the second part of Article 22. Detention of a person cannot exceed 3 months unless advisory board reports the sufficient cause. That you have understood, and they will include the high court judges, either former judges or present judges, or somebody qualified to be a judge. Grounds of detention should be communicated, but here the ground of detention means extension beyond 3 months, right? Should be communicated to the detainee, and no need to disclose any important facts which can go against public interest. Also, opportunity has to be given to the person who is detained to make a representation against the detention order as soon as possible. And the last clause says that Parliament by law can prescribe under which circumstances and classes of cases person can be detained for more than 3 months under a preventive detention law without the opinion of the advisory board. Also, maximum period can be prescribed by the Parliament for which a person can be detained in any classes of cases. And the procedure to be followed by advisory board in an inquiry can also be prescribed by the Parliament. I hope these things are now clear to you. You should have understood about the differences between punitive and preventive. You should have also understand about arrest and detention. Now, there are certain other information, as I've said, which is given in your book about the preventive detention, the laws related to it, what is the situation in US, UK, India में कब से है, so the history to it, etc., etc., why it is needed, why it is not banned, what is the correct data about it, the current one, the contemporary issues, all of that, you know, the arguments favor, against, and all of that analysis perspective I will take in the issues related to preventive detention in another video. But firstly, I'll finish all the articles. So now that we are done with Article 22, our next set has to be Article number 23 and 24. See you guys in the next video. Thank you so much. Take care. Bye-bye.